The first object is to resolve the dispute. And the third strategic aim of the Chartered Institute is to develop and support an inclusive global community of diverse dispute resolvers. Why we use the word diverse? Because Pakistan में ये समझा जाता है कि probably lawyers are the only one who can deal with the legal terminology. तो यहाँ पे architects and engineers शायद lawyers से ज़्यादा हैं in global industry. Because construction industry जो उनकी है वो पूरी arbitration और ADR के ऊपर ही चल रही है. Then we have got medical experts, we have got accountants who are very good arbitrators. So हम एक diverse जो dispute resolvers हैं उनको हम create कर रहे हैं. At the same time, with regard to the values, we say dignity and respect. As the Chartered Institute, this is what we promote. Treating all individuals with respect, valuing their contribution, recognizing the importance of diversity by the inclusion of all. I think it's time this generation has to play their part. हमें diversity, inclusion और insight को हमें extremism वाली जो हमारे ऊपर labels लग रहे हैं हमें उसको काफ़ी हद तक mellow down करना शुरू हो गए हैं. Probably another few years to come we need to deal with it. Professionalism, working with mutually a clear sense of commitment, respect and direction. गलत है बहुत ज़्यादा professionalism का काम है. It's just you just can't say and go back to your client and date डल गई थी या date हो गई थी या हम available नहीं थे. We need to change this culture within ourselves as well. And these are the values जो कि हम as Chartered Institute promote करते हैं. And then ownership and accountability, self accountability और आप चीज़ को own करेंगे तभी आपकी एक dignity and respect जो उनसे है वो develop हो सकेगी. With regard to the history, I just informed, we were founded in, not in 1907, it's 1915, and we were granted a Royal Charter in 1917. As we speak today, it is the only membership body that oversees the global promotion, facilitation and development of all forms of private dispute resolution. हमारी 100th anniversary जो सी वो 2015 में की गई थी, and I welcome you all. We are all available. You can reach out to us through the website. आपको किसी किस्म का कोई मेंटोर मेंटी प्रोग्राम्स चाहिए हो, कोई इन्फॉर्मेशन चाहिए हो, ब्रांच विच इज एट द मोमेंट लोकेटेड एट लाहौर, बट हम वी हैव द रीच पूरे पाकिस्तान के अंदर. आपको हर किस्म की वहाँ पे इन्फॉर्मेशन भी मिल सकेंगी, हम आपको बैकअप भी दे सकेंगे, एंड वी आर मोर देन हैप्पी टू गाइड यू एंड बिकम डिस्प्यूट रिजॉल्वर्स rather than litigants. Thank you so much. I'll invite Nasir to come and give you a bit of brief about what a dispute is and what are the different types of dispute resolutions which are available. Thank you.
अभी मियाँ शराज जवेद जो कि चार्टर्ड इंस्टीट्यूट ऑफ आर्बिट्रेटर पाकिस्तान ब्रांच से बिलोंग करते हैं थे, उन्होंने आपको अवेयरनेस दी है अल्टरनेट डिस्प्यूट में. अब मैं रिक्वेस्ट करूँगा मिस्टर नासिर खान MBE वाइस चेयरमैन ऑफ दी चार्टर्ड इंस्टीट्यूट ऑफ आर्बिट्रेटर तशरीफ लाएँ. आराम से.
Thank you. Right. Assalamu alaikum all. Why do we need lawyers? Why do we need lawyers? Has anybody thought about it? Why do we need the legal profession?
Only for justice, only for justice.
Exactly. Access for justice, rule of law. What happens when we don't have rule of law?
So there's chaos.
It is chaos. The society goes into despair. There is no order. We are heading towards anarchy, absolutely. So rule of law is the most important aspect to have a just society. So we are here as advocates of creating a just society, and that's why we take it as an honor and a pride to be lawyers, because we are the ones that enable access to justice. Okay? Why do we need access to justice? We need access to justice when we go into a dispute. So my question to all of you is, what is a dispute?
The disputes are both of parties, both of neighbors, both of traditions.
Disagreement?
Absolutely. So I'll go with the place where I went for education. Okay, so in the Oxford Dictionary, the true meaning of a dispute is, it is a misunderstanding between two or more parties. I can't have a dispute with myself, right? I mean, that would just be silly. So you need at least two or more people to have a dispute. So any misunderstanding is a dispute. How do we resolve a dispute? What do we do? What are the options? And this is where we, as lawyers, need to think about, if we need access to justice, if we need to hold the flag of rule of law, how do we help the general society, the society that we live in, how do we help them to promote this, to give them the options of how they can resolve disputes? So think about it on the ADR continuum, okay? What options do we have? What is the most favored option in the society at the moment? Can anybody tell me that?
Arbitration, sir. Arbitration is the
So it's,
Okay.
sir, the most prominent one is going in the jirga systems and the local systems of dispute resolution. Yeah, I think.
You're all right. Okay. So let me tell you on a scale. Okay. So the scale is a more facilitative element. So I'm going to draw a line. Let's say we've drawn a line in the middle of this room. So more facilitative element is on the left side and more adjudicative is on the right side. Okay? So let's start from the most adjudicative side. On this side, what's here, the most adjudicative? You practice it day in, day out. It's litigation, right? It's going to the court. Okay? What is the extreme left process? No, not really jirga system, because if a party is in a dispute, they talk to themselves, table talk, right? Negotiation. So, more facilitative, you're starting with negotiation, and then on the other end, you're talking about litigation. It's very difficult. What we learned over the last week, lawyers who've been practicing litigation for 20 plus years, to talk to them, how can we do mediation and negotiation? Don't ask. It was fun over the last week. Qazi Saab was amazing. He was one of the candidates doing the mediation course. It's amazing to see him here at the moment, sitting here, because he's got his exam later this evening. So we all get to go through exams, etc. But you're absolutely right. We need to think about negotiation is the first element, then litigation. So I'm going to move on this scale slowly but steadily, and just follow the process with me. So from negotiation, you're then moving towards mediation. And there are different types of mediation. The one that we have focused here is facilitative, where you don't give advice, you don't give options. The parties come to their own conclusion. You just facilitate them. So have you considered this? What other options do you have, etc., etc. We're not giving, we're not judges. Then you move towards evaluative mediation. You basically say, you know what, I've looked at your case, I think you need to do this, this, and that. That's a bit more evaluative. From there, you move into neutral evaluation. You appoint a neutral, and the neutral decides for you what's happening. It's still facilitative because the parties retain control. From there, you're moving towards med-arb, mediation and arbitration. It's a bit of a hybrid. Started, some people like it, some people don't like it, it depends. Then you're moving towards adjudication, arbitration, and again litigation. And in between arbitration and litigation, some people also hire private judges. And the reason is there is a discussion on arbitration going on, whether arbitration awards should be made public or not. The whole reason why people choose arbitration or mediation or any other aspect is because they want confidentiality. They do not want their dirty laundry hanged in Pakistan law side, okay, or LexisNexis, or Westlaw, or whatever it is. Court cases are public; they are in the domain of the public entity. So, if private matters are to be discussed, what would you choose as your lawyer, as their lawyers? So, when parties are coming to you, it's your prerogative how you advise them. I asked a question to some very learned person once, and I'm going to ask that question to you. Either raise your hand or don't raise your hand. Is the customer always right?
Yes, sir.
Okay.
That is a commercial answer.
Yeah, I know. Okay. So the answer that I received from this person of over 50 years standing, okay, and it was in a different concept. We weren't selling things, we were consultants and advising them on different matters, and we had a very difficult client. So I asked the senior partner of the firm, is the customer always right? And his advice to me was, it's a two-pronged answer, as you can imagine. Every lawyer doesn't give a straight answer. He said, yes, but if it is an informed customer. So what have you done to inform the customer what they need to do? I want to see them in court. Yeah, calm down, let's discuss, let's evaluate what other options do we have, because if we are not discussing those options, the customer has got something in their mind. We're sellers, lawyers, consultants, whatever we are, doctors, we sell things. As Mia Saab mentioned earlier, we sell a service. So if we are selling a service, we need to be customer oriented. Mia Saab mentioned very clearly integrity. Integrity is not just about ₹1 million fee, 2 million, 3 million, 4 million. Integrity is how you can help your customer choose the best option. And this is where ADR continuum comes into play. What is the right way forward? I'm not saying do a multi-tier, negotiations may fail, go into mediation, may fail, go into expert evaluation, may fail, go into arbitration, may fail, and then go into litigation. No, it depends on the type of the case and things like that. So what we did on behalf of the Chartered Institute of Arbitrators is we did a research report. I don't know, I'm sorry, I would have shown you on the multimedia, but this is an HDMI only and they have a VGA port, so apologies on that. But if you can write it down, there is a link called pcdr.pk. It's Pakistan Construction Dispute Report.pk. And the whole perspective of that report was to try and identify how different regions in Pakistan approach dispute resolution. What is the main cause of dispute? So I'll give you an example. We can sell ADR as much as we want. We can sell litigation as much as we want. Avoidance is better than cure. Majority of my practice now is advising clients how to avoid disputes. I work in infrastructure and transport sector. Okay, so that's majority of my litigation and arbitration is only 1/3 of the element. 2/3 is advising how not to get into that position. We need to understand the root causes of disputes. Okay, there is no point a client coming in, you've built 10 stories of a flat and then says, oh, can you add 4 more? It doesn't work like that. There are consequences, there are situations. In Pakistan, the most prominent disputes are payment delay, extension of time because you couldn't deliver on the time agreed with the client, and then the third one, which is very difficult to comprehend, behavior and competency of people. Behaviors destroy things. Collaboration is the most important key for anything that we want to do and achieve. So with that, once we understand what the different root causes of disputes are, then we can provide a good solution to avoid them. So for example, why are we having payment delays? What are the terms in the agreement on payment? What are the aspects? Because you will be drafting contracts very soon. You will be looking at all those aspects. So apologies on the slightly construction and infrastructure oriented explanation. I have absolutely zero practice in criminal, so I can't give you any advice on that. But yes, please.
I have a question. So when we are drafting agreements,
Yeah.
there is usually a clause where it's about dispute resolution
Yeah.
and arbitration,
Yeah.
and we refer to the Arbitration Act 1940
Yeah.
of Pakistan. So my question is, can I draft an agreement where I can restrict both the parties from going to the courts, instead only opting for arbitration?
Okay, very good question. So, New York Convention 1958, arbitration awards are enforceable with all of the signatories of the New York Convention 1958. Now, it generally applies in international arbitration matters. In domestic arbitration, it has to be enforced utilizing the Local Arbitration Act. The thing that we need to understand is I'm not here to criticize the 1940 Act. I've written extensively on it. 1940 Act is archaic. It should be in a museum. I end it at that, because 1940 Act does not support arbitration in the way the world has moved on since 1958. If we look at our neighboring countries, India updated its act in 1996, Bangladesh updated in 1996, India has since updated it 4 times. So I'm currently part of the English Arbitration Act 1996 Review Consultation Committee. And in arbitration, once you have an arbitration clause, the jurisdiction is with the arbitrator, not the courts. So the arbitration clause has to be written precisely and specifically defining everything. That, as you mentioned, if the parties go into a dispute, the dispute will be resolved under arbitration. The arbitration seat would be this, the arbitration procedure would be X, the arbitration law would be Y. So the contract law, the arbitration, just one more second. In some contracts that we have, it would say, if there is a dispute between the parties, you get multi-tier clauses as well. The parties should resolve amicably, otherwise they go to mediation, otherwise they can go to adjudication if it's England, or they can go to the sole jurisdiction of the courts of England and Wales. But if there is an arbitration clause, the jurisdiction of courts of England and Wales is sidelined. So your question, please.
So this is not what we are practicing here. We put in the arbitration clause, and at the end we write, the courts of Islamabad shall have exclusive jurisdiction to deal with all disputes.
So it doesn't work. So it's not, both clauses are then unenforceable because they are contradicting. So in drafting, you've got to align it from that perspective, whether the jurisdiction is with the arbitrator, because there is a case, Pizza Hut by Justice Jawad Hassan in Lahore, where they have mentioned recompetence, which is an international case which gave guidelines to arbitrators that they can define their own jurisdiction. The problem with arbitrations in Pakistan at the moment is conflict of interest and impartiality issue. So let me ask you one thing, okay? If you have a claim with WAPDA, you are a contractor and you have a claim with WAPDA, okay? And WAPDA says the arbitrator is going to be my ex-general manager. How are you going to proceed with that arbitration? Because there is absolutely zero impartiality. And this is what's happening in Pakistan. So an arbitration is conducted. Of course, the ex-GM decides in favor of, I'm sorry, I shouldn't be naming companies, right? So apologies on that. But these are some of the things that we need to think about. On that, I'm going to pass it on to Qazi Saab because he's just looking at me because he knows I need to go. The thing is, ADR globally is moving into different directions. You've got ombudsman, you've got regulatory authority. For example, SECP here is a regulatory authority, looks at it. Then you've got ADR centers. In some places you've got court and ex mediation. In Pakistan, we have a law which Qazi Saab is going to explain further. Qazi Saab, may I?
ADR Act 2017.
ADR Act 2017. In Punjab, we have 2019, which I believe is not enforced. It's just there sitting and waiting.
I just have one more question.
Yes, please.
So University of London is offering these two courses. applicable laws and procedures in international commercial arbitration, and the second one is regulations and infrastructure of international commercial arbitration. If we pass these two courses, we are entitled to apply to the Chartered Institute of Arbitrators as a member.
Yes.
Is it beneficial for us to get this certification in Pakistan? How will this benefit us in Pakistan if we are a member of the International Chartered Institute of Arbitrators?
Everybody is a member of the International Chartered Institute. There is no membership of Chartered Institute of Pakistan. Chartered Institute of Pakistan branch is just a branch to help promote the international element, right? So everybody is reviewed and taken exams in every aspect on an international level. So if you're a member in Pakistan, you're not a Pakistan branch member, you're a global member. So that's one thing. When you talk about further education, having done 3 masters, what I would say is getting fellowships and things is more practical and is more showing your skills as a competent practitioner. But when you go into education, it's how you convert that education element into your practical aspects. So the course that the gentleman mentioned is about regulatory aspect of international arbitration or the practical aspects of international arbitration. It will give you the necessary skills to apply at your workplace because it's knowledge. Rabbi zidni ilma. So you can never stop learning, and we should continue to learn. So, and that would be my suggestion to all my learner colleagues, and on that I will disappear. Thank you very much. Oh, we've got a few questions. Just very, very, very briefly, please.
You have said that treat your clients as a customer. So, do you think acquiring justice as a noble cause stands on a similar position when we treat customers as when we treat clients as customers? Do you think that?
So I'll give reference to hadith. Okay, a Bedouin comes to Rasulullah sallallahu alaihi wasallam and asks him sallallahu alaihi wasallam that I want to be the most just man. That was the question. I want to be the most just man. So what Rasulullah sallallahu alaihi wasallam gave the answer was very simply, choose for others what you will choose for yourself. And that's the answer for that. Whether you treat them as customers or money, it's entirely up to you. But we have to remember that we have to work under the guise of our faith, because risk comes from Allah. We have to strive, work hard, we all do. That's why you are all sitting here. But risk comes from Allah. So inshallah, when you work with that in mind, inshallah you will succeed. Last one, please.
Sir, I have a question.
Yes, please.
Sir, you mentioned about the goal of a lawyer is to seek justice for people. I respectfully disagree. I feel like we have to achieve legality rather than justice, because we stand in the court of justice. We do not stand in the court of justice, but rather in the court of law. So what are your comments on that? Do you think that in arbitration and mediation, is that sort of a court of justice compared to the court of litigation, where it is, let's say, it's a court of... what I'm trying to say is, do you think that arbitration and mediation is like something where you strive to achieve justice, while in litigation we strive to achieve legality?
Very good question. So I will give a reference to our society as a whole and the difference between ADR and litigation as an aspect. Just think of it this way. When you're doing litigation, you're looking at the past. She did this, he did that, who did that. You're all looking at the past. But when you're doing mediation and ADR, from that perspective, you're looking at the future. How can we go from this amicably? And that's what you need to look at. As a society, Islamic tradition, South Asian aspect and things like that, we need to differentiate between whether we want to be that element in the past, or should we look forward in the future with the hope and the benefits that it may get. your point about as lawyers, we are, say, the custodian or the supporters of access to justice and rule of law. Well, that's exactly what you need to be doing. Conciliation is written in the Quran, right? Surah An-Nisa, Ayah 34. Okay, and it says, when you've got a problem, you pick one arbiter or a mediator from this side, pick one arbiter or a mediator from the other side. So why is that? Why is the Quran or the Hadith not saying go to litigation? There is several hadith and several saying of the Hazrat Umar radiallahu anhu and several Khilafah who basically mention that try and resolve your dispute. Litigation should be the last resort. I hope that covers my point. Okay, I'm so sorry. I need to disappear now. Qazi sir.
So my question please. मैं इधर ही हूँ आपके सारे सवालों का जवाब दूँ इनसे पूछ के बता दूँ
हमारी ये खुशकिस्मती है कि हमारे पास गवर्नर मियां शराज साहब और नासिर खान साहब तशरीफ लाए. आई एम थैंकफुल टू बोथ ऑफ देम ऑन बिहाफ ऑफ IPC. और अभी हम 10 मिनट की ब्रेक करेंगे. जिन लोगों की टेंडर्स भी वो टेंडर्स जरूर करवा देंगे. 10 मिनट की ब्रेक के बाद कायद साहब भी तशरीफ लाएंगे और उसके बाद साहब तशरीफ ला रहे हैं, उनका लेक्चर होगा. इसलिए टाइम का ख्याल रखिएगा. 10 मिनट की ब्रेक है, उससे ज़्यादा फिर बुलाना ना पड़े. थैंक यू वेरी मच.
जो पिछली इसमें था वही था नंबर लास्ट में याद वो मैं ऐड मुझे नहीं मिला
And just quickly, I'll give.
हमारे पास है